Good afternoon, everyone, and welcome to Export Justice, Not Jails, a virtual discussion on the export of U.S. criminal justice practices, sponsored by Incarceration Nations Network, Juvenile Justice Advocates International, and Fair Trials. We're very grateful to our sponsors and to each of our expert panelists for making this event possible. My name is David Fathi, and I have the honor to introduce and moderate this discussion. I serve as director of the National Prison Project of the American Civil Liberties Union, based in Washington, D.C. The National Prison Project works to ensure that conditions in U.S. prisons, jails, and other places of detention meet minimal standards of health, safety, and human decency, and comply with both domestic and international law. We also work to reverse the laws and policies that have led to mass incarceration and to the extreme overrepresentation of people of color in the incarcerated population in the United States. The United States is a global outlier in many respects when it comes to criminal justice policy. Perhaps most significantly, it has both the largest incarcerated population and the highest incarceration rate of any major nation, and by quite a significant margin. The per capita incarceration rate in the United States is almost 4 times higher than in Mexico and about 6 times higher than it is in Canada. It is an outlier in its use of solitary confinement. There is no other country in which solitary confinement is such a routine and integral and of the incarceration regime. Prison privatization is common in the United States, but unknown and sometimes legally prohibited in other states. Certain features of pretrial procedure in the United States, such as the use of cash bail and plea bargaining, are unknown in many nations. These practices would be troubling enough if they were confined to the United States. But what is even more concerning is that both through US government action and through the actions of private actors, they are being exported to other countries around the world, often with disastrous results. And that is our topic for today. It's now my pleasure to introduce today's panelists. Douglas Keillor is the executive director of Juvenile Justice Advocates International, based in Mexico City. They work to promote alternatives to deprivation of liberty for youth and to protect the human rights of children in conflict with the law in Latin America. Dr. Stuart Schrader is Associate Research Professor of Africana Studies at Johns Hopkins University and is the author of Badges Without Borders: How Global Counterinsurgency Transformed American Policing, published by the University of California Press in 2019. Dr. Boz Dreisinger is a professor at John Jay College of Criminal Justice, the founder of the college's Prison to College Pipeline program, and the founder and executive director of Incarceration Nations Network, a global prison reform and justice reimagining organization. And Verónica Hinestroza is senior legal advisor at Fair Trials, a global criminal justice watchdog campaigning for fairness, equality, and justice. She specializes in the interconnection between human rights and criminal law. We'll hear from each of our speakers, and then we'll have time for questions and discussion. Please put your questions in the chat, and please indicate if they're for a specific speaker or for the panel as a whole. With that, our first speaker is Douglas Keillor. He'll be presenting the newly released Export Justice, Not Jails fact sheet on U.S. international criminal justice aid and an overview of the challenges of spreading U.S.-style criminal justice practices and opportunities for sharing better practices. Douglas.
Thank you, David, and thank you to all of our panelists and our attendees. We're very excited to be able to share this important topic that often feels like it is overlooked. I think it was a great introduction that David provided for kind of the context of our discussion today. As David mentioned, I'm the founder and executive director of Juvenile Justice Advocates International, and we work in Latin America with the majority of our work and our headquarters in Mexico City. Our engagement with this issue started very early on in our organization's work. We've been working on alternatives to incarceration for about 10 years in Latin America, and it was probably about 7 or 8 years ago when we first started encountering U.S. prison practices being brought into the juvenile detention system in Mexico. And in particular, we began to see prisons starting to transform from kind of a typical Latin American juvenile detention center, which isn't a great place to be in general, but into a much more high security type of infrastructure and high security types of policies and procedures being put into place. And we learned to find out that this was part of the U.S. government funded initiative in conjunction with an advocacy and industry group in the United States called the American Correctional Association, was brought in to accredit adult prisons in Mexico, and actually began their process in the juvenile detention system. And this became very troubling for us as we saw literally walls go up, more barbed wire fences go up, and literally no changes to the human rights and corruption situation that we were encountering in those facilities. And so that was our first encounter with it. I also would note that specifically with the American Correctional Association, is kind of one of the things that kicked off this group was that Senator Elizabeth Warren's office published a report called the Accreditation Con about the American Correctional Association specifically being used in immigration and federal facilities in the United States. But we saw these trends kind of replicating themselves in Mexico and Latin America. So with that, we're very excited today to be able to release for the first time and publish for the first time our fact sheet on export justice, not jails, looking at U.S.-funded criminal justice activities from 2013 through 2022, taking a look at about a 10-year time frame. I think it's important to note that if you want to go ahead to the next slide and start to get a look at some of those numbers. These are the numbers over that 10-year period in the millions. Here are broken down by the types of projects that we were able to identify that those funds were going to. But this represents over $5 trillion in spending over that time period, and broken down into police, prisons, courts, and then other kind of general or unspecified aid. The next slide also then breaks these numbers down by, if you want to go ahead to the next slide as well, looking at specifically which U.S. agencies are spending these funds. And the majority is from the U.S. Department of State, including USAID, some funds from the Department of Justice, and from the U.S. Department of Defense as well. I don't want to paint with too large a brush and say that all of these policies are replicating mass incarceration activities. We think it's a real mixed bag of what sort of activities are taking place on the ground. But it's also very hard to dive in and determine more specifically what are some of the activities that are taking place on the ground. I think some of our other panelists speak to the research and activities that they've done and see what those activities look like. But in our experience, it represents activities and policies and practices that are based on a mindset that David gave a very good summary to, an accepted way of doing criminal justice, a way that in the United States is second nature, whether it's plea bargains, that almost all cases in the United States are resolved via plea bargains. And in places like Latin America, plea bargains or kind of negotiated or trial waiver mechanisms, sometimes they're called, or negotiated resolutions to cases, were unheard of maybe 10 or 15 years ago, simply didn't exist. And now they've spread throughout the region. And some of it's through direct funded policies, and other it's just, as David said, through private actors who come into the region with an accepted understanding that this is how criminal justice works. Whereas in those specific contexts, that isn't the understanding necessarily. But what we find, much like the example of the American Correctional Association, and how facilities that may have significant human rights shortcomings and failings, using the fact that they've been accredited by an American agency, or the fact that they're implementing programs and policies that are brought through the United States government as a shield, as a seal of approval that this is the modern professional way to conduct policing, to manage prisons, to design your court procedures. And so these numbers represent that mindset, right, going out into the world. And these numbers also represent the fact that the United States, the amount of funds that the United States is spending on criminal justice just far outshadow any private funders or foundation resources that would be going to looking at alternative types of programming that don't have that built-in expectation for how criminal justice systems are supposed to work. So we'll be sharing a link to the full fact sheet with all of the attendees, and so people can go ahead and download it. We're excited to raise awareness about this important issue.
Thank you, Douglas. Our next speaker is Dr. Stuart Schrader, who will provide some historical context for the phenomena that we're discussing today, and will focus in particular on law enforcement and security cooperation.
Okay, thanks. It's great to be here. Thanks to everybody for joining us. I want to use my brief time to make 2 points, which are based on research I've been doing. One result of that research is the book that David mentioned, Badges Without Borders. So the first point is that the exportation of U.S. criminal punishment tactics, technologies, procedures, and materials, which we've just been hearing about, actually has a very long history. And the second point is that despite this history, its goals and its organizations have changed somewhat over the decades, but they typically do come as goals of reform and modernization. And I think that this suggests that a critical perspective on the exportation of U.S. criminal punishment policies and procedures should not be primarily focused on reform and modernization. In other words, reform and modernization are built into the very project itself. So let me talk a little bit about this history, and we can go to the next slide. So this is a totally mundane image, I would say. What you see here is a car pulled off on the side of the road. It's in South Vietnam, but it could be, in whatever city you're in right now. And what you see is 3 Vietnamese police officers searching it for contraband, and there's a U.S. police advisor who's looking on and giving advice about how best to conduct the search. And so this is what a lot of U.S. police assistance has looked like. This is what it looked like certainly in the 1950s in the Cold War, and in many cases continues to look like. Now, this photo was taken just a few years after the end of French rule in Indochina, and it was prior to what we would consider the start of the U.S. war in Vietnam. Now, of course, the U.S. did wage a brutal and awful war in Vietnam, and this type of police assistance was included in that, but it was actually far more common around the globe in the period. And of course, it was also much cheaper than military engagement and combat operations. So this type of assistance happened in more than 50 countries. The idea was to train local officers, as you can see in methods of searching cars, for example. And these advisors oftentimes stuck around for decades. And in addition to sending these advisors to over 50 countries, around 75 countries sent their police officers, typically high-ranking officers, to the United States for training, including in facilities. One was in Washington, D.C., right in the center of D.C. in Georgetown. So we can go to the next slide, which has another photo, not particularly dissimilar from the prior one, in that you have U.S. police experts offering training to police officers from multiple countries around the globe. And these trainers were often some of the most well-known police experts in the country at the time. These were the guys who wrote police textbooks. They devised the latest and most up-to-date tactics and technologies. Although some of them were just regular old cops who had kind of risen up the ranks, and maybe they were bored, they wanted an adventure. So they left, Indiana or California, went to Brazil, went to Thailand and other countries on these training and technical assistance missions. So from 1962 to 75, this overseas police assistance operation as well as the Academy in Washington, D.C., was under the auspices of the Agency for International Development, or AID. Now, it came to an abrupt end in 1975 due to a number of allegations of abuse. Now, in the context of the Cold War, the police assistance mission was twofold. The primary mission was the prevention of communist subversion and revolution, which meant equipping police to crack down on political dissidents, including students, trade unionists, peasant land reformers, and so on. And the second mission, which overlapped or dovetailed with the political purpose, was cracking down on crime, whether smuggling, unauthorized border crossing, narcotics trafficking, or a range of everyday crimes from burglary to homicide. And whatever the goal, the argument was always the same. Police and punishment systems in aid recipient countries needed to be modernized and reformed to deal with emergent threats, including corruption, that plagued many of these agencies in other countries. So these allegations of abuse began to emerge around 1970. They entailed accusations that police advisors were teaching torture, overseeing prisons with horrible conditions that even held children. And then in 1975, Congress decided to shut this program down. And to this day, this law remains on the books, stating that the U.S. is not supposed to give police assistance to other countries except under certain circumstances, most prominently for control of narcotics trafficking. So now when most types of police assistance do occur, they're no longer under the auspices of AID, and they require working around some of those restrictions put into place in the 1970s. So let me wrap up by showing you a picture from today. And I don't need to explain too deeply how much this echoes the prior photo. This is a marksmanship training that you see going on in Iraq. This is a US expert similarly training his counterpart in how to fire a weapon accurately. Here, the difference is that this trainer works for the Department of Homeland Security, specifically the Border Patrol, which is part of Customs and Border Protection. He's part of BORTAC, which is the specialized tactical unit, something like the Navy SEALs for the Border Patrol. Now, we could, of course, ask why the Border Patrol, whose mission is ostensibly to control the borders of the United States, was operating in Iraq. And that's a question maybe for another time. But I just want to emphasize that whereas there was one agency involved in the 1960s doing this police training and assistance, which had centralized oversight, direct links to the White House, today there is no centralized oversight. Many, many agencies play a role, private contractors involved receiving a huge amount of money to engage in this work, but they're still engaged in a reform and modernization mission, and it's still oftentimes organized around both the control of forms of political radicalism and control of crime. So I don't want to take too much more time, but I just would like to emphasize that although there has been a qualitative transformation from the period of the Cold War to the present, in terms of the government agencies involved and the oversight of it, I think we should be careful about a narrow technocratic argument that we should reform this system in order to better reform police overseas. That's basically what was happening in the 1960s when all the operations were under one roof. And I think the risk is reproducing the problems of the prior era. I think instead, as our panelists are going to talk about, we need to question whether the goals of this assistance are appropriate, whether the assistance is achieving its goals, and whether the U.S. actually has the expertise to provide assistance in criminal punishment, considering all of the failures and the size of the contemporary police and prison system in the United States. So I'll stop there. Thank you.
Thank you, Stuart. Yes, indeed, it is worth wondering whether the U.S. is in a position to give lessons in this area, given conditions that currently exist in the United States. Next, Dr. Boz Dreisinger will talk about the history of U.S. exportation of prison practices, from the first modern prisons through solitary confinement and more.
Thank you so much. So I begin with 3 photos, and we can just show them consecutively. So there's one, actually Jamaica, that's Chile, and there's the third, that's actually Australia. So the Australia-Jamaica labels got mixed up, but I think the essence of it is you can see something about these 3 facilities. One of them which is that they look vastly alike. Tower Street Correctional Facility, built in 1845 in Kingston, Jamaica for 650 people, and now home to about 1,700 incarcerated people. Fremantle Prison in Western Australia, built during the 1850s as the region's biggest colonial prison, which it's now a museum. And La Penitenciaria in Chile, built in 1843. All of these are in obviously very different ends of the world, and yet they look radically similar. And that is not an accident. To give you a bit of prison history in a nutshell, in the 1820s, the US invented the modern prison system, creating two prisons, Auburn and Eastern, in Pennsylvania and New York, based on European philosophical ideas floating around at the time. Auburn was essentially a factory, a temple to capitalism, where incarcerated people were put to work in lockstep, making things like Civil War Army uniforms. And Eastern was based on the idea of a monastery, the term penitentiary, penitence. And in fact, I often say that it's important to remember that the US has been wasting money on prisons for quite some time. There was running water at Eastern before there was running water at the White House. That's how deeply invested the US was in building this first modern prison and having it be a central facet of our identity in the US. Obviously, both of these models are still very relevant today, but Eastern was a sensation, and individuals, country leaders from around the world, much of which was under colonial dominion at the time, came to see the prison, came to visit. Charles Dickens was a famous visitor, Alexis de Tocqueville. And ultimately, given that the world was under colonial dominion, what you saw was a replication of this exact panopticon-like facility, this penitentiary Eastern model in more than 350 locations around the globe. And so really, this marked the start of the US's exportation, our innovations, and then exporting practices to the world. This, of course, was inherently tied to the development of solitary confinement, which really began in the 18th century with the Quakers experimenting with solitary cells at the Walnut Street Jail in Philadelphia. And then, of course, we have Eastern, built on this solitary confinement model, put people in cells with a Bible and they will repent and all will be well. But in the 1980s, in 1983 to be exact, the first 23-hour-a-day cell isolation policy in a control unit in Marion, Illinois, became the Supermax, the first Supermax. Other states followed suit, especially as tough on crime rhetoric was intensifying and the US prison population was soaring to obscene levels in the next 2 decades. So, of course, you had Pelican Bay, you had Colorado's so-called Alcatraz of the Rockies, ADX Florence, and of course, what you saw then were other countries following suit and visiting especially ADX Florence. I wrote an article which we at Incarceration Nations Network posted on our socials over the weekend about Brazil. I visited the growth, one of the Supermax, one of 5 Supermaxes that were built in Brazil based on the US model, where I was overtly told, yes, we visited the US to see this. In New Zealand, Auckland prison, it also revealed that its Supermax unit was modeled after Marion. South Africa has 2 Supermax facilities, were products of tours to FDX Florence and Marion. And in fact, the American Correctional Association has even published a guide to opening and running Supermaxes called Supermax Prisons Beyond the Rock. Another US innovation is prison privatization. That's another one that has spread across the world, particularly to Australia. In my book, I spend a chapter writing about the Australian prison system, which holds the world's largest proportion of incarcerated people in private facilities. About 20% of its prison population, and boasts a wholly private immigration detention system, which of course the US has followed suit in. And so, you know, in my travels first in writing Incarceration Nations, the book and now in running Incarceration Nations Network, the organization, I'm told again and again and again by our partners that US-style draconian drug policies, mandatory penalties, one-size-fits-all punishments, these are all the things that are packing the prisons in their countries too, and that are products of US exportation. So Douglas has already shared the data in terms of how this translates to the modern day, available grants for agencies to come get trainings, whether it's at ADX Florence or the training facility right nearby in Colorado, whether it's grants that are spent arming police forces, literally building prisons. I was in the prisons in Colombia that the US funded. The US just funded the building of a massive prison in Guyana as well, which governments are often all too ready to take the funding for because their old colonial prisons are literally falling apart. And so the attitude is, well, we can take this and at least have a modern prison to lock people up in. When of course they're not addressing the root cause of the mass incarceration crisis. I'll just say a couple of things briefly before I sign off about the work to address this. What can we do? And the work of Incarceration Nations Network. Douglas and I have known each other since the founding of the network, and we collaborated in Mexico. This is the first thing that we talked about. What can we do to stop the exportation of these practices? Certainly conversations with US and advocacy around the US agencies that are funding this and pushing them to catch up with the times. So much of what we're funding in the US is more progressive work. And whether that's on a city level, at a federal level, on a state level, but yet the money that is being spent to export practices is stuck in the draconian eras. And so certainly advocacy around getting these entities, these very powerful US State Department entities, to rethink what they're spending money on is a tremendous part of the strategy. We also want people to know this is happening. Most Americans have no idea that their taxpayer money is supporting mass incarceration all around the globe. At INN, we have two, in addition to webinars like this, which I think are really important, we don't talk about this issue enough. INN has produced two short films about the issue. One is the first episode of our docuseries, which is a history, sort of a history of global prisons in a nutshell. It's on our website, Incarceration Nations, a global docuseries. The introduction is titled The Nefarious Plot, an introduction to global mass incarceration. And we also produced a short film about this issue specifically around supermaxes in Brazil, which I mentioned earlier. And then lastly, certainly, well, two more last things. One is that we are very eager to connect with US funders who support wonderful work in the US, but often the work stops at the border. And we'd like to see that change because we are responsible for this mess. In my article in The Atlantic, I call it an American nightmare from which the world is still waking up. We made a mess. It's our duty to clean it up, or at least be part of the cleanup of that mess. And so we would love to see US funders be more transnational in their thinking and in their work. And we would like to see the resources of the global North benefit the global South in other ways. And so a lot of the work that we do at Incarceration Nations Network involves connecting our partners all around the world. We have 127 partners, Fair Trials, JJAI are among them. And these are partners from all over the world. And by connecting them, by seeing them collaborate and work together, we hope that we can reverse this by connecting our formerly incarcerated leaders who are part of our Global Freedom Fellowship for formerly incarcerated leaders from both the global North and the global South. We're already seeing collaborations that allow for the spreading of resources in a powerful transnational way to think beyond borders. So I leave you with that. Thank you so much.
Thank you, Boz, and thank you in particular for addressing the all-important question, what can we do about it? Next, Verónica Hinestroza will speak about trial waiver systems, the global trend of expansion of trial waiver systems and how they affect fair trial and due process guarantees and human rights, with particular focus on the case of Mexico. Verónica.
Thank you, David. Good afternoon. It is a pleasure to be with you today and to co-organize this event. Douglas, thank you so much for your leadership. David, such a privilege to have you as a moderator, and fantastic to listen to the other panelists. I also want to acknowledge the number of colleagues that are following us online. It's fantastic to see you all as well and interested in this topic. So as David mentioned before, Fair Trials is an international civil society organization dedicated to monitoring criminal justice systems around the world. The organization works towards fair and equal criminal justice systems. And within that work, we have tracked and analyzed the growth of waiver or alternative to trial mechanisms since 2016. And we have the particularity of looking at this from a human rights perspective. So I am going to go deeper into what trial waiver systems are, in case not everyone is familiar with them, but in particular, to make sure that it is understood why it is so problematic that they are expanding around the world. So to start with, I want to remind everyone that fair trial, it's a right. The trial is a right. It's meant to be a public hearing by an independent and impartial tribunal established by law. And trials are important because it is where judicial truth is publicly established and a person is found guilty or innocent following a thorough investigation process, a public discussion of the evidence, both followed by the accusation and those accusing and the defense. But the trial is also where the accused person has a chance to defend themselves after months or years of criminal investigations and significant amount of time usually spent in pretrial detention. So trial is very, very important to justice. And it is also where the actions of the police and the prosecutors are finally exposed to judicial scrutiny. So without this public mechanism, it's really hard for civil society organizations or for other legal actors to monitor whether the police and the prosecutors are actually following human rights and best practices for the investigation and the production of evidence. Now, trial waivers, known in the US as plea bargaining, as some have already mentioned, take place when someone who is suspected of a crime gives up the right to the trial. So it means that they give up the right to provide evidence, to challenge evidence, and to be presumed innocent, which is, of course, a key standard of the justice system, the presumption of innocence. In return, they usually receive some kind of benefit, for example, a sentence that is supposedly lower than if the case went to court and they were found guilty. This varies from country to country. Fair Trials has published a number of studies reviewing the functioning of trial waiver systems around the world. By 2015, we have found that the system has been expanding to around 90 countries. And that meant that it increased it increased 66 countries from the 1990s to 2015, and it only continued to increase. In the case of the US, as it has been mentioned already, trials have virtually disappeared. Fair Trials has noticed that at least 97% of federal cases are ending in plea bargains. And in one of our recent studies in Europe, we found that at least half of the cases are ending in also plea bargainings, of course, again, depending on how they are called in these jurisdictions. In Mexico, where we have been working and we conducted one of our latest studies, we found that in the federal justice system, the abbreviated procedure, which is the name of the trial waiver system, is becoming the most common form of early termination of proceedings. In 2021, federal pretrial courts concluded 64.7% of the criminal cases in abbreviated procedure sentences. So in general terms, Why is this expanding? Because it in theory offers like important benefits. It reduces the workload of prosecutors and courts and defense counsel, as well as reduces the time of proceedings, and therefore it's considered to improve the punitive effect and conviction rates. They are also credited with facilitating the strategic implementation of cooperation agreements, particularly in Latin America regarding drugs, the drug cartels, drug mafias, and to tackle corruption and complex organized crime networks. However, in practice, what we find is that they dilute the investigation process. Prosecutors do much less to try and find or present strong evidence. And they also lead to diluting the guiding principles of the accusatory system. They tend to prevent the discussion and evaluation of aspects related to the circumstances of the crime, the circumstances in which the crime was committed, the nature of the crime, and the nature of the evidence. And in this context, we are very concerned about human rights violations, such as torture for the purpose of obtaining information or a confession, punishment or discrimination, as it was mentioned before, as well as the illegality of detention, because they remain hidden. These things can be happening, and the pretrial, the plea bargaining system does not allow this to be visible. And in theory, plea bargaining is reached through consent, but we find that that is a complete myth. People end up accepting a plea bargain even if they're innocent, although most of the people will say that only a guilty person will accept such a deal. But the truth is that there are a number of elements within the criminal justice system that push people to accept a plea deal. And that includes lengthy and costly proceedings, the fear of getting a higher sentence if they go to trial, family reasons, the need to get out of prison, maybe facing torture or I forgot the word in English, but it was mentioned before. So, you know, all these circumstances in prison that shouldn't be happening, and the only way to escape, because they usually tend to negotiate when they're in prison, they tend to negotiate the plea bargain when they're in prison, lead them to accept to move into a plea deal. And we are very concerned because courts are not really scrutinizing trial waivers sufficiently. Judges kind of are very much left on the side, and we don't know if they realize actually their job is disappearing with plea bargaining. Of course, if there are not trials, the role of judges is really not going to exist for much longer. But in general, we're concerned that there's no opportunity to scrutinize this. Most donors that are not, of course, and I'm not talking about the US donors, but don't see the criminal justice system as linked to human rights. So it's kind of an area where most programs related to human rights and justice do not get involved in. And civil society really lack the tools and the funding to look further into these and to analyze the trends and understand why it is such a concern to continue to have this trend growing. So yeah, we think, you know, more opportunities to monitor these and to scrutinize what is happening will be ideal, and that we all have a role to play in doing so. But certainly more opportunities for other sort of funding, and realizing that this is getting more and more. It's because it was created in the US, and the US unfortunately does not necessarily follow human rights law. It's not incorporated into the treaties. The model is exported, as in the other countries where it is used, human rights were not also upheld, and they uphold, and they are. In most of Latin American countries, of course, in Europe, we do sign human rights treaties that should be applied to any proceeding within the criminal justice system. So this is, of course, a problem that requires looking deeper into it. Thank you.
Thank you, Verónica. Thank you to all our panelists for their valuable contributions. We now have about 15 minutes for questions and discussions. If you have a question, please put it in the chat. I will take the prerogative of the chair and ask the first question myself, primarily or initially to Douglas, but others should weigh in. How does the U.S. funding of this kind of exploitation of U.S. practices compare with other funders, and what are the impacts of this kind of funding on local civil society organizations, criminal justice reform organizations in the recipient countries, the countries where the funding is directed?
Yeah, David, I think that's a really important question, and I mean, as evidenced by the fact that a number of us have mentioned that in one way or another in our discussion. Just looking at the raw numbers in our firsthand experience in Latin America is that the sheer amount of funding is just dwarfs any sort of, whether it would be potential government funding directly from the like Latin American governments or from private funders. There are private foundations and private funders that do fund some justice work, but the reality is that it's a tiny amount in comparison. We don't have the numbers yet at this point, unfortunately, but we can say with quite certainty that we know a number of organizations that are able to, if they get, say, a USAID grant, are able to ramp up and have full operations for a number of years while that contract's ongoing. And when those contracts end, there's just nothing to replace it. And so we also have partners that have worked with us to get information specifically on this issue of exporting U.S. practices. But then because of the influence of U.S. funds, they're reticent to publicly join this type of discussion, I would say, because they're funding, and for oftentimes very good work that they're doing is largely coming from the U.S. government, or in some part coming from the U.S. government. So it has kind of this distorting effect as well on the whole discussion that I think is really potentially really damaging, that you don't have a full broad discussion about what are alternative ways to look at justice systems. Should we be talking about abolition type policies in other countries? But these, looking at more kind of radical solutions to a really significant social problem isn't on the table for civil society in these countries. So I mean, I think that's part of the reality that we see. I'm sure that some of the other panelists can speak to their experiences as well.
In addition to questions from the floor, I would certainly invite panelists to pose questions to each other. So this is more of a free and full discussion. I have a question for Verónica. I believe your recent report on Mexico discussed in particular some of the effects on women. Could you talk a little bit about that?
Sure, thank you. Yes, we were looking at whether women were more vulnerable to accept a plea deal than men within the criminal justice system in Mexico. We found that they are. In most cases, women are accused of crimes together with men and are often involved in criminal activities because of their emotional or familiar relationship with men, because of pressure, or because they are, at the moment where men are arrested, they are working for them in cooking or cleaning or carrying out sex work, and they are just detained with them and face kind of the same criminal procedure. And some of them are just charged for that, for accompanying or covering for men, without the reasons being properly considered by prosecutors who are charging them. So as I was mentioning, plea deals do not really provide for the opportunity to look deeper into human rights concerns, and this is also the case for applying a gender lens. It's really hard to understand why women were involved in the crime and in the situation through plea deals. So we also found that aside from these, they are very likely to accept a plea deal even if they are innocent, because women are usually abandoned within in prison, women are more likely to show up for men when they are in prison, but men usually abandon women after a period of time for different reasons, but also their family. It's very hard for them to visit because probably they will be taking care of their children and other obligations that before were, the responsibility of the women in prison. So this abandonment also push them to accept a plea deal much more than it happens with men. And we found other, other reasons behind this, but what I would really like to say is that we again need to monitor this with a gender lens, a human rights perspective, to understand the implications.
Thank you. We have a question from the floor. What can members of the general public do to learn about, to push back against these phenomena? I know Boz started to talk about that, but perhaps other panelists have ideas as well.
I'm happy to say a bit more about that.
Please,
and pass the mic. Yeah, and also to your earlier question, David, which Douglas took on. So I think one is, as I said, I think people, one thing the public can do is get educated about this issue in a transnational context. And again, that's something that we do, certainly Stuart's book, my book. There are other organizations that, Penal Reform International in the UK, does wonderful transnational work as well. So looking at that material, INN's 2 films that I mentioned, but I also hope there'll be opportunity. I mean, we certainly see this webinar as the start to a larger action campaign, which includes spreading this message, but also advocacy around the higher ups. And so perhaps petitions and getting signatures. Again, this is U.S. taxpayer money. So, we as Americans, we should care how our money is being spent, whether it's inside our borders or outside. And I think that's very, very critical in terms of the general public. Also, just knowing and perhaps supporting these organizations that are doing this work internationally and doing it on often a shoestring budget and without any public support on a level that is very extreme. In the US, we have successfully, as a movement, catapulted this issue to the forefront in ways that we should be proud of and that I think are moving the needle in all kinds of beautiful ways. That is not the case internationally. So, our partners on our website there, you can check out who our partners are. And again, Fair Trials, JJI are among them, and find out ways to support them in even a small way. I mean, it's $200 can move mountains in Bolivia, for instance. Our partner in Bolivia just produced a whole incredible podcast on the plight of incarcerated women with that small amount of money. So I think that's tremendously important. And I think too, we certainly plan to, and Douglas, I'm glad you clarified that we're not painting with a broad stroke. This varies quite a bit from country to country, based on the context of the country and also the priorities. Historically, we realize that, as Stuart was mentioning, the Cold War and the boogeyman, there's always a boogeyman that the US is invested in battling. And whether it's, communism/socialism, whether it's terrorism, whether it's the border and enforcing the border. And so all of that determines priorities in various countries and funding amounts. So, understanding that we are talking about this with nuance and with country-specific context, I think is also really, really important.
Thank you.
Yeah, and if I could just add a little bit, that those are all really wonderful points, and I think that as Boz said, it is U.S. taxpayer dollars that we're talking about. But the effects of these policies, as everybody has said, are really wide ranging, and it's really unfortunate that a lot of Americans really have no idea what's kind of going on in their name and the way that these policies are being spread around the globe. And to the degree, I think one of our real motivations here, as we've already mentioned, is to pay attention to really positive transformations that have been happening in a lot of cities and states around the country, criticisms of mass incarceration, efforts to decarcerate, efforts to find alternatives to kind of police first solutions to social problems. And so, my hope or maybe aspiration would be to, infuse those into the kind of conversation about what foreign policy could actually look like. And also, trying to find ways to partner with folks across borders. I mean, so much of the question of what is happening at the U.S.-Mexico border, or just kind of the ongoing debate about immigration, I think we underappreciate the way that U.S. security policies have actually been driving the way that governments around the world operate that are in many cases causing people to migrate. So actually, it's not just about us in the United States and our tax dollars, but it's also about the effects around the globe. And we need to find ways to create partnerships and solidarity with folks. And these organizations, as well as others, provide the platform for us to think about creative new solutions that are not, again, police or prison first, or really trying to focus on the boogeyman, as Boz said. And I think it's incumbent on those of us who care about this to create those partnerships and change the discourse, change the conversation, and find new solutions.
Thank you.
Yeah, if I can add, just kind of piggyback onto that and go kind of the next logical step, I think that this all stems from obviously a resource imbalance, and also a mindset of the way that we're doing in the United States is the best way or the right way to do it. I think there needs to be a real opening up of the discourse in the United States as well, both with governments as well as with the advocacy community, because there's a lot that can be learned in the United States from what is happening in other countries. I mean, our work specifically in the juvenile justice system, to say that you would send a child into the adult court in the adult prison system for a crime they committed under the age of 18 is unheard of. All 50 states in the United States send children to adult court. They're just starting to now end juvenile life without parole in the United States with these second look bills. I mean, the idea that you would wait 15 years after they've been in an adult prison for 15 years to give them a parole hearing or a second look, again, are pretty much unheard of in other countries. And that's what the advocacy community is pushing for, because otherwise it's condemning children to die in prison in the United States with never taking a second look back. So, I mean, from that to the idea of having defense counsel during police interrogations, is almost a laughable idea. And in Maryland, they passed a law to ban police from lying to children during interrogations, and the police and prosecutors are screaming against this law, trying to get it repealed. So, I mean, there's just some very basic things that you say that almost seem inconceivable in the United States when you don't look outside of the borders to see what's happening. And so we would love to see it become more of a two-way street. Stuart talks a lot about in his research the kind of the boomerang effect that these policies have on when how these kind of come back to haunt the United States, when these police and law enforcement practices kind of come home to roost. I mean, can we create a positive cycle back where we're hearing and seeing how other countries are, from a human rights lens, are looking at procedural and substantive human rights in the criminal justice system. So I think we have a lot to learn in the United States about ways to ensure the human rights of all people who are in conflict with the law.
And I just have to jump in because that's such an important point that Douglas just made, as in terms of the learning happening both ways. One of our premises at INN is always that this is a two-way street, that we can learn from other countries, they can learn from us, that these are, that this should never be just one way exportation of something. And often what we find is that when the US does look outside itself, it either looks at sort of the usual suspects of Norway, Scandinavia, Germany, without considering the progressive work that's happening in the global South and in many other countries. And so that, I think, needs addressing. And also that it be done in a non-extractive way. And that when the US does look outside its borders, that it's not only thinking about what can we extract from there and take back, but how can we as well be contributing and supporting and making this as much of a fair exchange and a sharing and a collaboration as is possible.
Well, unfortunately, our time is almost expired, so that will have to conclude the discussion for now. I'd like to again thank our sponsors, Incarceration Nations Network, Juvenile Justice Advocates International, and Fair Trials for bringing us together today. I thank each of our panelists for so generously sharing their time and expertise. And I thank all of you for joining us today. We very much hope that this will be the beginning of a continuing conversation and collaboration.